Hi, Shalev Amar here with your Lemon Law Advocates. And what I would like to tell you about is 6 costly misconceptions about lemon law claims and how to avoid them. So number 1, the first misconception is believing that if you've had repairs done for free under warranty, that there's nothing you can do no matter how many repairs you have or how much time your vehicle is in the repair shop, because after all, it's being done for free. You might even be provided a loaner. That doesn't make a difference under the law. The warranty obligates the manufacturer to do repairs. And when you buy a new product, that's part of the purchase price of a product. A brand new product, that's why it costs more than a used product. A warranty is part of that cost. So the lemon law and other breach of warranty laws step in when the repair history has become unreasonable, when there's too many repairs or too much time in the repair shop. And it doesn't matter if the repairs are free. So don't think that just because the repairs are free that there's nothing that you can do. Second misconception. The second costly misconception is believing that you can handle a lemon law or breach of warranty matter on your own and contacting the manufacturer on your own to try and resolve the matter. Now, some people think, if they're having too many repairs, too much time in the repair shop, the product's defective, they didn't get what they paid for. Okay, well, maybe it's like a DVD player or a TV. That's defective. I could just contact them, no big deal, they'll just swap me out or give me my money back. Unfortunately, that's not the way it works. And one of the reasons is because a car is a much more complex product. Any vehicle is, whether it be an RV, a trailer, a motorhome, a boat, and it's not the same as a cheap consumer product. It's a high ticket item. And what you have to understand about these companies is oftentimes they're not looking out for your best interest. What they want to do, because a small percentage of vehicles don't come out right, no matter what the company is, no matter how high level a company it is, it's just with mass manufacturing, a small percentage of products just don't come out properly. And what the company is trying to do, the company's motivation is to limit their costs, limit their expenses for defective products, because it cuts into their profits. And just to give you a perfect example of this, I'm sure you've heard on the news where there could be a $20 to $100 part, company doesn't do a recall, and people get hurt or even die. And so the companies do that because it's cheaper for them to pay out on the individual claims than to do a recall across the whole product line. So if they're willing to do something that might even lead to people getting seriously hurt, injured, even killed, what makes you think that they're going to give you the maximum under the law if you contact them? On top of that, this is the other thing that you have to understand. When you're dealing with this kind of issue, it is a legal issue. If you were to be hurt, if you needed surgery because you had a broken arm, would you try and put your arm back together, create your own splint, and then do surgery on yourself? Of course not. Why would you try and do the same thing with a legal matter? What you need to understand is the company's representatives are legally trained. Sometimes they're even attorneys. Why would you want to go into the lion's den from a very unequal knowledge position? And so it's just not recommended. And look at your own job. Imagine your job that you do every day, that you have experience doing. Now, consider, would somebody coming off the street who's had no training, who's had no experience, would they be able to do your job as well as you? Would they know everything that's associated with your job? Would they know the pitfalls to look out for? Of course not. So what makes you think that you would know that with a potential legal matter? So what you have to understand is both Congress and many state legislatures added attorney's fee provisions to the lemon law and other breach of warranty laws because of the unequal bargaining position and knowledge position between these companies and consumers. So because of that, you can get free legal help. The companies have to pay the attorneys as part of settlement if the case ends up settling or if you win in court upon resolution. So if you can get free legal help from a trained attorney who has experience dealing with these companies, who has experience dealing with these legal issues, why would you not take that free help? Why would you try and handle this on your own, where you can end up accepting a deal that's not even close to what you're entitled to, and then signing your rights away, and if you keep having problems with your vehicle, you come to a firm or an attorney and they can't help you because you signed your rights away. Even if the company were to offer you the max under the law, let's say they offer you a repurchase or replacement, there's still details involved with that. They might not give you everything you're entitled to. And again, it's because they have experience dealing with these matters and you don't. So I urge you to not go into the lion's den on your own. If you hire an attorney to handle this type of matter, with our firm in particular, we're able to settle 95% of these cases out of court, no charge to you. It's anywhere from 15 to 30 minutes of your time total from start to finish. Everything can be handled over phone, email, and fax. It's virtually painless. Why would you not want to have a trained attorney helping you with something that quickly and that easily? And then you don't have to deal with the stress of negotiating with a multi-million, even a multi-billion-dollar company on your own. You have the attorney to do that for you. And the attorney has a fiduciary duty to you. That means they have a duty to act in your best interest. These companies, they don't have that duty at all. So please, don't try and handle these types of matters on your own. It would be a big mistake. Number 3, the third costly lemon law misconception is believing that it would take too much time or cost you too much money to pursue a lemon law or breach of warranty claim with an attorney. Again, not correct, and I alluded to this briefly. The time commitment is very minimal. Typical case, anywhere from 15 to 30 minutes of your time for the out-of-court process. Again, 95+% of the cases are resolved out of court. As far as money, it's not going to cost you anything for the out-of-court representation, at least not with our firm, because we don't charge our clients for out-of-court representation. We seek all our attorney's fees from these companies. And with our fair fee guarantee, we'll never ever get paid any more than you for out-of-court representation. So just understand, it's not going to take you a lot of time. Like I said before, everything can be handled through phone, email, and or fax. You won't have any hearings to attend because it is out of court. The attorneys will do all the heavy lifting for you. You can just sit back and relax, and then you'll be contacted to discuss settlement offers or to provide vehicle records if we don't already have those from you. So again, understand, as far as the cost, out of court cost is zero. As far as time commitment is almost nothing. 15 to 30 minutes of your time. 15 to 30 minutes to potentially get the vehicle bought back or get it replaced or get even thousands of dollars in compensation in the alternative. I don't know what job you do, but there's not many jobs where you could get that level of compensation for that small of a time commitment. So please, please, don't believe that this will be something that's time consuming or costly. It's neither. Number 5. Sorry, not number 5. Number 4. We'll get to number 5 soon. Number 4 is believing that you don't have a valid lemon law or breach of warranty case if your vehicle is finally fixed, no matter how many times it's been repaired or how long it's been in the repair shop. Again, that's incorrect. If your vehicle is finally fixed, that's wonderful. That's great that they fixed it. But you know what? Guess what our most finite resource is? It's not money. You can always make more money. It's your time. The time that you have spent going to the repair shop over and over again. The time that you have spent without your vehicle. You will never get that time back. The aggravation and the inconvenience of dealing with repeat repairs, of dealing with a defective product, that's worth compensation as well. And if your vehicle is truly fixed, And time will tell. It might not be based on the prior repair history, it just might be at that moment. You should still pursue the matter for compensation because, again, time is money. You will never get that time back. Once that time bank account has been drawn, it's gone. Okay? So you deserve to at least be compensated for that. And like I said, for your aggravation and inconvenience, for basically having overpaid for the product. And if while you're dealing with the matter, you start to have repair issues again, then guess what? Then we can push for a repurchase or replacement or higher compensation. So again, don't think that if your product's fixed, that there's nothing you can do and that you don't have lemon law or breach of warranty rights, because you do. Number 5. 5 is incorrectly believing that the repairing dealership that you've been dealing with will be upset with you if you pursue a lemon law or breach of warranty matter. What you have to understand is that even though a dealership sells and repairs the manufacturer's product, they are not the manufacturer. It can be a little confusing because they've got the manufacturer name all over the dealership, and also, brochures and selling materials, things of that nature. But they are not the company. They are independent entities. The way you need to look at it is like if you were to buy a TV in Best Buy, and let's say it's a Sony TV, Best Buy is not Sony. Best Buy is an independent entity, and it's the exact same thing with car dealers, with boat dealers, with motorhome or RV dealerships. They are not the manufacturer. So the lemon law and breach of warranty laws apply to manufacturers for the most part. Even in the limited circumstance where there is a law that applies to the dealership, dealerships are generally indemnified by the manufacturer. So if that type of law is brought up, like one example is revocation of acceptance under the state uniform commercial code, but that's just to have the extra claim and extra negotiating leverage against the manufacturer, because manufacturers, like I said, indemnify dealerships for these types of claims. So it's not costing the dealership any money. It really has no effect on the dealership if you pursue a lemon law or breach of warranty claim against the manufacturer. Number 6, the last costly misconception about lemon law claims is believing that that if you have a settlement and the settlement is for cash compensation with you keeping the vehicle, that means that your vehicle will be tagged a lemon, or that you no longer would have warranty coverage because they paid you money. Neither one of those are correct. First, let's talk about tagging the vehicle a lemon. The vehicle only gets tagged a lemon under the law if it's reacquired by the manufacturer, if it's bought back or replaced. Then it's the manufacturer's responsibility to tag the vehicle a lemon. Usually they have to fix notification on the vehicle, and they also have to provide written notification to subsequent purchasers. It could also be reported in various internet databases. That doesn't happen with the cash compensation settlement. That'll actually be confidential, so that won't be in any type of public database, and your vehicle will not get tagged a lemon whatsoever. So you don't have to disclose your vehicle as a lemon, and you don't have to worry about your vehicle being depreciated by this settlement. It'll be confidential. As far as warranty coverage, your settlement will have no effect on any remaining warranty coverage. In fact, we actually make sure that in settlement paperwork that they expressly will continue to honor the warranty. So you don't have to worry about that issue either if you have a cash compensation settlement. So those are the 6 costly misconceptions that you want to avoid if you're thinking about pursuing a lemon law claim. I am licensed in Arizona, and I am the founder of Amar Law Group. We are a multi-state firm that has a team of attorneys licensed in multiple states. We're working on becoming a national firm. Please contact us with any vehicle issues, and just know that if we don't happen to have an attorney licensed in the state that you're in, we're here to help. We'll help you find local counsel.